everyone, Derek Johnson with Tatango.com. Today we're doing another TCPA case review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. Hey Joe, how you been?
I'm doing well, Derek. How's it going?
Can't complain. We were just talking earlier, we're doing another case review, and we're doing one on Buffalo Wild Wings, and now we're doing one on edible arrangements, and it's 11:50 a.m. here, and I'm starting to get hungry, so we'll try to rush through this as quickly as we can.
Okay. Your doctor would encourage you to eat the edible arrangements before the Buffalo Wild Wings, but...
Except the ones covered in chocolate. Those are the ones that always get me.
As long as it's dark chocolate, right?
That's true. That's a different video. Okay, so we have, this case is, like I said, edible arrangements. So it's Rando versus edible arrangements. And Rando is not... doesn't stand for random. It's the person's last name. I thought this was like a rando person. Plaintiff Nicole Rando. She is suing edible arrangements. And edible arrangements, if you can't tell, it's those like baskets full of like fruit that kind of look like flowers. And sometimes they put like chocolate on them. They're really good. Check them out. I'm a big fan. If anybody wants to send me one, you're welcome to. Or you, I bet, too, would like one. So
Delicious.
This is a class action lawsuit, which maybe before we jump into it, what is a class action lawsuit? Like, what's the difference between a regular lawsuit and a class action lawsuit, just in general?
So if you hit me in your car, I would sue you, Joe Bowser versus Derek Johnson, because you hurt me.
Okay.
If I thought that you did something that hurt people in the same way that you hurt me, an environmental spill, this kind of a TCPA case, you can bring the case both in your individual capacity for the harms that you suffered, allegedly, and on behalf of all other people that have similarly, situated positions. So the lawyers will fight over the extent to which people are similarly situated, but the idea is the procedural vehicles allow you to say, hey, it would not make any sense for each of us to come and bring a separate lawsuit. So if you can fit within the parameters of Rule 23 of the Federal Rules of Civil Procedure, you can bring a class action both on your own behalf and on behalf of everybody else who has a similar injury where the court wouldn't have to have a mini trial.
Okay, so
for each and every person.
If you spammed, let's say, 100,000 phone numbers, instead of requiring each phone number to bring their own court case, hire their own attorney, clog up the courts with 100,000 people, this would essentially consolidate it into one, and that's that kind of, it's a class, right? They're creating a class of people.
Correct. Yeah, you wouldn't. Not every TCPA case is appropriate for class certification, of course, right? And in a lot of our cases, when something like consent takes over, right, where you have to look at on a case-by-case basis, did Johnny consent? Did Jenny consent? Did Joey consent? That case, we would argue, and courts agree, isn't appropriate for class certification because you still need those mini trials. So if you're not getting the administrative savings, among other things, you won't get class certification. Okay. But yeah, if you just bought a list without regard to whether they gave you consent, you threw it into your dialer and started pushing out phone calls, and there aren't really those consent issues and other individualized issues, then yeah, that's probably a case where class certification is going to be granted.
Okay, so this woman, she's saying I was harmed, myself, the woman, but also I know most likely there's other people out there that might be harmed as well.
Right.
And her harm that she's claiming in this lawsuit is, so she opted in to receive marketing text messages from edible arrangements. So this is very similar to many brands, how they use text messaging. Opt in, usually get 20% off to join the list. And then, weekly, monthly, you get promotions and coupons, and you can opt out at any time. So great use of text messaging, especially if you're opting in, then it follows the rules as long as you're doing everything correctly. So it doesn't sound like that's really in debate right here. It sounds like what is in debate here is she, at a certain point, and I don't know how long she was part of the campaign for, she said, you know what, I don't want to receive these text messages anymore. And what a normal person would do, or what myself and hopefully most consumers would do, is they would reply stop or unsubscribe to a text message, or just even text the word stop to the short code. And then the software provider and Edible Arrangements would take that phone number, just like you can unsubscribe from email, messages, and they would unsubscribe that person and no longer message them in the future.
Correct.
That's the way everything should work, and usually that's how most consumers opt out. Now, this woman tried something a little different, maybe a little more unique. She started texting back phrases, essentially, similar to kind of stop and unsubscribe, but most likely the software provider, it's not that smart, so it doesn't know that these phrases are trying to essentially say stop or unsubscribe, but without saying stop or unsubscribe. So she said, number one, take my contact info off, please. So no stop or unsubscribe in that message. So it's kind of hard for a software provider to figure out what she's trying to say. Number two, I want to confirm that I have been removed off your contacts. Again, no stop or unsubscribe in that message. I asked to be removed from this service a few times. Oh, this one does say stop. It says stop the messages. Most SMS providers that I know about, usually you have to text stop or unsubscribe kind of as its own message, essentially. Maybe a signature or quotation marks will still accept that. But it looks like this woman was essentially going out of her way to text everything but stop and unsubscribe. So what's the case here? So they didn't unsubscribe her, but she was asking to be unsubscribed. How did this end up for Edible Arrangements?
Well, they got to win. They got to win because the fight was over whether Edible Arrangements could establish a single means of opting out, i.e. texting just stop.
Okay.
STOP.
Yep.
Right. So she was saying it's not lawful for Edible Arrangements to prescribe a single form of opt out, namely texting stop.
Yeah.
So because, and this is not unfair, she was relying on the FCC's 2015 declaratory ruling, which said, and this has been upheld now by the DC Circuit, consumers can opt out by any reasonable means. So she said it was reasonable for her to communicate with an SMS platform like I would with a human being.
Okay.
Right. And so that was her argument, that it was illegal for Edible Arrangements to only accept one form of revocation, namely the stop.
Okay.
And the court had to balance whether her form of opting out was itself a reasonable means. Right. So that was the tension. The court had to figure out, did she have a reasonable means? And if so, was it okay for Edible Arrangements to try to, supersede that reasonable means by saying you really only can text stop to opt out? And the court ultimately found that her method wasn't reasonable. And the court looked at the totality of the circumstances, which is what the FCC has asked the courts to do, and found that it is so simple to text stop to a computer.
Yep.
And it is not reasonable to think that the computer has that higher level of artificial intelligence to read your otherwise polite messages and discern that you wanted to opt out, particularly in light of the ease of just texting the 4 letters.
Yeah. And I think the CTI and the CARES, it's like stop, unsubscribe, remove, quit. They have a few different, and most software providers comply with all of those. And I think it's interesting to note here, because there may be some people that watch this that aren't in SMS marketing. I'm speaking kind of out of term because I don't know Edible Arrangements, but I'm guessing most likely no human saw these responses.
In my experience with platform providers, it's extremely uncommon that you'll just start reading logs of messages.
Yeah, because let's say you have 1 million subscribers and you send out 1 million messages, and these people have all opted in. Mm-hmm. People are going to respond back with, questions and gibberish. There's all kinds of things people respond back. They have autoresponders, hey, I'm driving, this text will be read later. So they get thousands or even tens of thousands of responses. And most brands just kind of ignore it, essentially. It's kind of like replying to an email marketing message. Most likely it's not going to be read. So this wasn't Edible Arrangements looking at this message going, oh, she's saying take me off contact info, take my contact info off, please. But you know what? We want to keep this subscriber because it's just one phone number extra. That most likely wasn't them. If I see these kind of things and I'm looking through replies, usually even I'll just kind of like unsubscribe them, but most people aren't even looking through the replies. So this person was kind of, in this middle zone where they weren't texting stop, but they were trying to opt out, but no one's actually listening to what they say. Now, was there any, I know in other cases, it's been very obvious how to opt out. So there's instructions in text messages, in the mass messages, or when she replied, take my contact info off, please, it sent back a message going, hey, we don't accept responses. Please reply help for help, stop for stop, terms and conditions apply. Does it say anywhere in the case that was like it was obvious that she could reply stop at any time?
Yeah, this platform provider didn't give those responses.
Okay.
When it didn't respond, when it didn't understand the response, it didn't send that type of automated message that we've seen where it says, I don't understand your response, text help for help, stop for stop.
Okay.
So Edible Arrangements platform didn't send those I don't get you messages.
Okay.
But it did comply with the CTIA expectations that you will have the stop command.
Yeah. And so maybe like during the opt-in, it was like, welcome to our club, text help for help, stop for stop, all those kind of things. Also, I think it's getting more common now that consumers have at least interacted with a few SMS campaigns. So they kind of understand the rules. It's like, I understand that in an email, I go down the very bottom, I can find a link that says unsubscribe. I'm starting to get used to how to do things. And I think consumers are starting to get used to how to opt out of a text messaging campaign.
Right. Well, and we don't know this particular plaintiff's motivations, but we've covered cases, together where it was pretty obvious that the plaintiff was doing everything they could to avoid texting stop so that they could gin up their TCPA claims.
And explain that. So there's something called a professional plaintiff, and essentially it's somebody that is trying to create a TCPA case. So again, we don't know, but this person 100% could have known, that you reply stop to a message, but they were just almost trying to make a point that, they, used all these different methods, but, at the end of the day, they weren't removed, and they knew they wouldn't be removed.
Right. So there are plenty of cases where these professional plaintiffs, according to them, have like manna from heaven just been signed up for these text campaigns, right? They have no idea how a particular brand got their number, but they started receiving text messages. And then what they do to increase their alleged damages is to start having a conversation with the platform where they send in gibberish, and then they, of course, get a response. And then each response they get, they say, oh, that message violates the TCPA. There's another $1,500. There's another $1,500. So they'll just text the gibberish over and over and over again and say, I got 115 messages. My damages are substantial. And then they go and sue. We talked about a Seventh Circuit case where that appeals court basically said that plaintiff was not going to get any discovery or any damages about any message after they clearly were gaming the platform and just failing to text stop. Like when he texted questions to the platform and they sent us a response back that said, I don't understand your question, text help for help, stop for stop, the appeals court said, we're not having any of that. That's not the kind of message that the TCPA was designed to guard against.
So it's a way to almost speed up the damages, because let's say Edible Arrangements was sending one message per month to all their customers, and this plaintiff, let's say, was like, ooh, I could wait either 12 months and have 12 text messages times, let's say, $1,500, or I can get my first text message and respond 100 times, and based on the CTA and the wireless carriers, the software provider always has to respond back. It can't just be like a no reply type email. We always have to respond back with something. Even if it's not helpful, we have to respond back with something. So it's a way for them to drum up more text messages in a shorter amount of time, essentially.
Which they allegedly didn't consent to.
Yes, correct. Yep. And I guess and we've been kind of harping on clients to do this lately, is if someone wants to opt out of your campaign. Now, I think maybe this was more along the lines of like the professional plaintiff where they're trying to game the system. But there are consumers that, let's hypothetically say, they don't understand. This is the first SMS campaign they've ever been in. Maybe the opt-in instructions they skipped over, they didn't really look at. There are consumers that are just frustrated and they can't figure out how to stop the text messages. Now, let's say we get a message from Chipotle and now they're vegan, or they move to a different location, they don't have Chipotle. There's reasons why you stop text messages. What we've been kind of advising.
They have tofu options, Derek.
Yeah, true. That's good. Yeah, I guess. Always throwing Chipotle under the bus. So we always advise our clients here at Tatango is if, for any response, even if it's gibberish, if it's a mass message, always give the instructions on how to opt out, because a person can turn into a plaintiff very, very quickly if they're frustrated. I've never seen somebody that is super happy with their Chipotle text messages, and then they can't figure out how to opt out, and then they reply, hey, I can't opt out, and responds back saying, please, reply stop, and then they reply stop. They're like, that was great experience, I'm out of the campaign. That doesn't frustrate people. I've only seen TCPA cases from professional plaintiffs and people that are just frustrated. Either they're frustrated because they're getting spammed, or they literally cannot figure out how to get out of the SMS campaign. So I would encourage most text message marketers and brands, look through all of the messages, the help, the stop message, the reply received, the opt-in message, weird things that people can text, make sure they're getting a response. That's key. You need to do that, but I've seen other people not do that. And make sure there's instructions that are super clear in those messages on how to get help, how to reply stop, making it just
and it was that was hugely important for this judge. That was hugely important, for her to see that each of those messages gave her the simplest of instructions of how to opt out, right? Reply stop to stop.
Yeah.
Everybody can get that, right? My 7 and 8 year olds would be able to nail that command, right? Yeah. So it really was important to this court that the message was so clear and easy to comply with, so that it helped the judge conclude that this really was the only reasonable way of opting out.
It brings up another point, too, for text message marketers. They may have not been able to defend themselves at edible arrangements if they didn't have good records, because it looks like, they present to the judge the whole text message flow, what was responded, then what the SMS provider responded, essentially giving them a step-by-step, SMS kind of chain, essentially, of what that person did. How long, number one, I think you should never destroy your SMS records, but how long do you have to keep them based on the law?
So the statute of limitations for the TCPA is 4 years.
Okay.
So you want to keep your records, particularly your consent records, because that's something that you, the defendant, has to prove. That's an affirmative defense. So it's on you to demonstrate that to the court. The plaintiff has to do nothing about consent. They just have to allege that they didn't consent to the messages, and they're off to the races.
So it's up to arrangements to prove that they didn't do this. So it's like accusing somebody without any evidence, essentially, and edible arrangements has to say, okay, here's all the evidence and here's all the logs. It's not like the rando person, Nicole, she had to take her cell phone and show the judge, hey, I got these messages.
Right.
Okay.
Right. Now, she did do that in this particular case because she needed to tee up the revocation issue for her case to make sense. Because once she admitted that she consented in the first place, she needed to establish that she actually revoked her consent such that all the messages after that were violative of the TCPA.
Okay.
So for her own reasons, she had to tee up the consent and revocation issue to tell the whole story. So in this case, some of the messages were obviously in her complaint. But yes, edible arrangements would have come forward with the complete conversation, which this court was allowed to look at because it was so essential to the allegations in the complaint.
Okay. Two other things, too. I know I've done a video recently about this is it's very often, especially kind of in our industry, so much consolidation and mergers and acquisitions, many companies and brands transfer their SMS list to another SMS provider. I think it comes back to this isn't something where you just have to keep records of the phone numbers, like a list of the phone numbers that have opted in, or even the opt-in records. You have to keep really every single message that goes in and out on that short code. Because I could see even in this case, let's say somebody's replying, take my contact info off, please, and maybe it doesn't trigger, a message back. That's just kind of like a message that's kind of in the air, essentially, on some platforms. So It's not just like, hey, we send this mass message to these phone numbers and that's the only record you got to keep. You got to keep if they responded 10 days later, if they just text in randomly to your short code and they don't hit any of your lists or campaigns, you have to keep a full record of every transaction on that short code, even if it has nothing to do with a list or a campaign or they trigger a keyword. And that's why we always recommend dedicated short codes, because with a shared short code, it's very hard to figure out which campaign they're trying to communicate with, because there's multiple campaigns on the short code. With dedicated, you should be able to pull a list of just every single message that has ever been sent out and in on that short code.
Yeah, and you brought up the possibility that people are shifting platform providers. You then want to make sure in all events, if the consent happened outside of the platform's context, you want to make sure that you keep the evidence of what that consent was, whether it was them filling out a website form, responding to a call to action. You want to keep that, whatever that advertising copy was that the consumer was responding to, or whatever the factual circumstances surrounding the capture of consent. You've got to keep that, because you need to be able to tell this judge 4 or 5 years later, depending on when the case is filed, what the story really was, with pictures and with a kind of illustrated flow from the user's experience. Because if you just show up with some spreadsheets, it's a hard story to tell, and it's much more compelling and probably probative if you have the full capture of consent.
And just to be clear, and I think you said this in another case review, which kind of hit home for me, is these judges don't just review text messaging cases all day long. They're not as educated as I am on text message marketing. They're not as educated as you are, or even the law of the TCPA. They're essentially being thrown all this info and trying to make a decision as quickly as possible. So you need to make this easy for them to understand. Maybe they have never even opted into a text message campaign. So having a picture of the billboard that was advertised, or listening to the radio content of, the ad on the radio, and then showing the text message logs and came in, went out, and this is what it looked like. All those things can help, because this judge most likely is not, as knowledgeable as most of us are that are watching this video.
Right. And the last thing you want is someone just testifying from their recollection about what a website looked at a particular time, or what an ad copy looked like, because it's on us, the defendant, to prove that there was clear and conspicuous consent that we got from the consumer. Yeah. You can't, it's the easiest way to show clear and conspicuous is to just show it, yeah. Right?
And we also do recommend, here at Tatango, a double opt-in as well, because let's say the billboard's up there, and maybe you do have, an image of the billboard. But then if you have the double opt-in, it essentially is reiterating all of the terms and conditions and, everything you needed to get that consent on the billboard is reiterating in text message. So at least you have a text message copy of that consent as well. So it's almost serves as your backup for, if somebody didn't see the portion on the billboard, or maybe they just didn't understand the billboard. Also, maybe if you lose the billboard, at least you have the text message record, at the very end of the day.
Right. If you have a self-contained environment in the SMS platform, you can still recreate that iMessage style message flow, right? Yeah. And the judge is going to get that, right? These judges can get into the 60s and 70s, but that's intelligible and clear to them, and they'll get it.
Yeah.
But the last thing you want is someone
explaining it, just being like, well, this is a text message, and they respond about it. They'd be like, well, that kind of sounds reasonable. Take my contact info off, please. I think, yes, you're right. And some of these judges are older. I've explained what our business is to some older folks, and sometimes they don't get it as well. I have to show them on the phone. So that does make a good point, is always keep your records, and not just the text message records, a screenshot of your website, a screenshot of the form. If you do any outdoor print advertisement or radio, television, take photos of it, and then just store it on Google Drive or Box or whatever you use and just keep it there forever. Right. It doesn't.
Well, because there are multiple audiences when you have to prove that you had consent, right? The first person you need to explain this to typically is the plaintiff's attorney, the most skeptical person you're going to talk to.
Oh, and the person representing the person that was harmed.
Well, the person who got the messages. Whether they were harmed or not is a different story. But yeah, so the first person you're going to show your consent records to is the plaintiff's attorney. If you have just a damning case against their client, they'll typically go away.
Because they may not be even educated on the TCPA, because they might just be a car accident attorney or a general attorney. They don't have as much experience in the TCPA as you do, where you focus only on telecom type stuff.
Well, even if they're a TCPA plaintiff's attorney, what incentives do they have to ask their clients hard questions?
Yeah.
Not many. They want to get the first case filed so that if there are other plaintiffs' attorneys trying to file similar cases, they're the first to file, particularly if they're class actions.
Oh, because it's the first attorney gets to kind of form the class usually. So it's kind of like a first in essentially gets the rights to it.
First to file doesn't always win the day, but it helps.
Okay.
It helps. And they know that. So, and in our experience, the plaintiff's attorneys don't always do the level of due diligence that you'd want them to before they smack a new client's name on a complaint.
Yeah.
I assure you that, we get complaints where the gender is wrong, the phone number is wrong. You wonder if they spent more than 6 seconds with their client. Yeah. Right?
And we've seen those like forums online where it's like, report your text message spam or something, to an attorney, and essentially you're just filling out a form, that it feels like a lot of these things haven't gone through kind of the due diligence that Edible Arrangements most likely did when they were served with the lawsuit.
Exactly.
Okay.
Exactly. Yeah. When you get one of these demand letters or a complaint, you're triggering hours and hours of work by the client and counsel to gather those records, put together the story of what happened, and then you share that with the plaintiff's attorney. And if you just have a database and some in-house people's recollection of how a given campaign looked, it's not terribly compelling. It looks like you have a he said, she said on your hands. So right there, you now have to get through the plaintiff's attorney. You have to get through the judge on what you hope is a decent summary judgment case, which is where you've gone through discovery. You think the facts are undisputed, but you still probably in the end may have something of a he said, she said case. And most often the judge is going to send that to the jury. So now you have 12 people who need to understand the lay of the land of the TCPA, and they may be coming at this with a residual hostility to unwanted calls. Yeah. So how solicitous are they going to be of a defendant when they hear about the kinds of calls that interrupt their dinner, that, bother them when they're driving, et cetera, right? So you may not have the most hospitable jury just because of what the case is about. So you have every incentive to keep your consent records so that you can tell that story, both narrative and pictorial, to put it all together and say, there's no way that this person should have thought that they didn't consent to get these messages.
So or really get out in front of it, essentially, before it gets too far in.
Right, because if you can tell that story from the beginning, the plaintiff's attorney knows they have an uphill battle, and they'll go and choose an easier target for that case, and maybe they'll make a nuisance value settlement demand, and then your client at least has a decision: do I want to go to bat on this because I did the right thing and prove my point, or do I want to just throw a few bucks at it and make it go away? And because we do the right thing, we're not going to get too many of these.
Yeah. Now, where did this get? This didn't get to a jury, right? This was thrown out? No.
This was thrown out at the earliest phase of the case, the motion to dismiss, where the judge essentially has to take the plaintiff's complaint allegations as true. And then in this case, you can look outside of the complaint if you need to get the full context of the conversation. So from some of the things the judge had said, she may have looked at some of the other elements from the SMS conversation between the plaintiff and the platform.
Okay. So,
but this seems for like Edible Arrangements, this is a big win because they didn't have to go to the more expensive discovery phase of the case.
And this seems like a big win for a lot of brands using SMS, because we've heard about these types of cases where people are responding back with kind of words that are similar to stop but not actually stop. It feels like after a certain point, after a certain amount of losing so many cases, people that are looking at the TCPA as an opportunity to make some money will look at it and go, okay, that tactic has been played out, and we're on to the next one. So do you kind of see that happening, that most likely we're not going to see many cases where they're responding, take my contact info off, please, and claiming that they just didn't know to reply stop? Or is it going to take a little bit more time for it to be completely just no money available in these types of cases?
I think we've seen the start of the snowball, but I do think it's going to take a while for the plaintiffs' attorneys and professional plaintiffs to realize that they don't have much room to move on this.
Okay.
And I've blogged about this before. I really think that this line of case law is much stronger on the SMS side than it is on the phone call side of the TCPA. Partial revocation and revocation case law on the voice call side of the TCPA is not nearly as clear as it is on the SMS side. And I think it really matters to the judges that they can see exactly what happened in black and white, where on the voice side of the call, you've got, a call center agent and a conversation. And, you and I right now, we might be talking over each other, or, there's just the vicissitudes of human communication that's live that doesn't happen when you can see it in black and white and you have the time to be deliberate about your response. And you're communicating with a machine.
Yes. Yeah.
Right. Like, it was important to this judge that the user's assumption and experience need to be brought to bear. And everybody should know that you are talking to a computer.
Yeah.
Right. And it's probably not as smart as Siri, probably not as smart as Alexa. And this SMS platform only is responding to certain command words.
Yeah. We do see actually clients nowadays, if you mass text message some people and then they respond back, some clients have even chosen to put, this is an automated response. Please don't reply to this message, text stop, to stop, help for help, because it's essentially giving them, instructions and telling them that it's like a no reply email. It's pretty obvious you're not going to get a reply to this. But yeah, that might be a good thing for every text message marketer that's out there. Run the gamut on your text messaging campaign. If it's a contest, see what happens if after you enter the contest, if you have a question, what happens? Does it just go nowhere? Does it respond back? And make sure that the instructions are clear. You never want to have somebody in your campaign that wants to get out. That's never a good thing. It's only going to hurt your brand. Yes, it might increase your subscriber numbers, but that's just it's like people hiding the unsubscribe link in an email. That's just going to piss people off. It's never a good thing. So maybe, all text message marketers, just even like today, if you have a short code and let's say you send out a message once a week, maybe your message is going out tomorrow, text in your short code right now and text, hey, I'm done with this campaign. See what happens, because I think that is the kind of things that happen in real life. And if there's no response, that's something you need to go to your software provider and say, there needs to be a response, and I need to be able to customize that response to make sure that people understand how to opt out. So maybe that's a good call to action right now, is just, go to your short code and start texting random things in. Text an image in, see what happens. Because you got to try all these different things that both professional plaintiffs will do and people that are just clumsy or they just don't understand how to opt out.
Right. I mean, we don't know Miss Rando's story. I mean, some of these messages, like, I could see my grandma writing this.
Yes, 100%. Right? Yeah.
Right. And if she's just not familiar with it and she really liked the first basket she got, we don't know her motivations and what she's really trying to do with this case. They're good. It could be entirely innocent, right?
Now, what happens also, and I know we're going a little long, but what happens if, because I know this is one kind of aspect of it, but what happens if this Nicole Rando, she goes into a store, she goes into Edible Arrangements, and she wants to revoke her consent to receiving text messages, and she asks the store employee and says, hey, I don't want to see these text messages anymore, remove me. Isn't that kind of the same thing? Like, we've established that they need to reply stop, or at that point, is that kind of like, you got to train your employees? Where are we at with that?
Well, that's an open question. The DC Circuit did affirm the FCC standard that consumers can revoke their consent under any reasonable means. So I think it would be very fact specific. If Edible Arrangements allows people to sign up for text messages in store, it becomes much harder for Edible Arrangements to say, oh, you can't opt out in store.
Yeah. Okay.
Right. Having a one-way door gets tricky. Now, I'm not saying that would always be the case. You can imagine a circumstance where the employee is just directed to have the customer go to an iPad where they can opt out, so that the data gets input to the place where it should go promptly.
Yeah.
You can architect revocation processes like that, but that gets expensive, right? Putting an iPad and training first-level employees about TCPA revocation gets expensive. I mean, imagine if you had to train every Target employee about how to revoke consent to Target text messages.
And it'd be everybody.
If they have 250,000 employees,
Yeah.
and there's an hour's worth of training there.
That's a lot. And it'd be everybody from delivery drivers to, the front people, on the lines, the security guard. Like, it could, where does that line get drawn? In those cases,
anyways, I don't mean to duck the question. It's just hard to answer in the abstract, because you want to know how are people able to enroll in the first place?
Yeah.
Because that'll influence how they should or could be able to opt out on the back end.
Yeah. We do always recommend to and this doesn't answer the question, but make sure your employees, and I know you can't force them, but make sure your employees are aware of the text messaging campaign. And usually we tell them to opt in, because then they get the messages that are the promotions. So when somebody comes in the store and they're like, oh, where's that 20% off thing? They're like, what are you talking about? I have no clue. They've received it on their phone. And usually if an employee has opted in, then they know how to opt out, and they're a little more aware of the campaign. Again, It's just these consumers that if they want to get out, you got to help them as much as possible. So educating your employees on the revocation, the TCPA, but then also just educating them that you have an SMS campaign, and here's how you opt in and here's how you opt out. And these are the messages we're sending. That can go a long way in just kind of helping the customer kind of figure out what's going on here.
Yeah, it's always a balance. You obviously want to avoid the situation where your consumer feels trapped.
Yeah.
Right. And they're getting messages that they don't want, and they feel like they can't get out of them. Right. Like, that's obviously an experience you want to avoid from a brand management and development perspective.
Yeah.
But you also want to avoid having to train every employee in the company on TCPA revocation issues. Right. That's needlessly complicated. And the high school kid pouring ice cream may not quite, may not get it. Maybe he does, because he understands
or he
SMS,
just doesn't care. Like, you're being paid a certain amount, like, it's not your problem. It's, I could see that.
Right.
The CTIA does do something interesting. They say that once a month in a mass text message, you have to put reply stop to stop, or stop to end, or whatever you want to put in there. It's essentially kind of instructions. I always recommend, if you have extra characters, if you're sending MMS, you always have extra characters. But if you have extra characters in your message, plop that message in there. You could do it every single message if you want. Every single message is going to protect you way more than once every month, and once every month is going to protect you way more than once every year. So, and then it would be nice, I think, like email marketing, you always have to have that unsubscribe. The problem with SMS is you get 160 characters, so sometimes you're just short on characters.
Sure. And I hear from time to time that they're discouraged from giving those instructions more than they need to, because they're afraid that they'll have a higher opt-out rate. You tell me, but I can't imagine that the data bears that out.
So they will have a higher opt-out rate, but if somebody wants to opt out, you don't want them in your list, and it could cause issues in the future. And then SMS is not cheap. So sending an SMS to somebody that it really doesn't want your messages is really just a waste of your time.
Right, and money.
Yeah, exactly. Yeah, time and money. So yes, the opt-out rate will be a little larger, but then you're
right. But you're cleaning out the people that you want to clean out.
Exactly. You're honing in your list. Your click-through rates are going to go way higher. Redemption rates are going to go way higher. So it has obviously it will reduce, but it will increase in everything that really matters. So I 100%.
And now that we
agree.
have the reassigned number issue back on the table in light of the DC Circuit's reversal, having those higher number of stop instructions will help the case that the next recipient of that number, if they get your messages because you didn't know the number was transferred to consumer B, you have now more defenses in your arsenal to say, I let them know that they could opt out by texting stop numerous times, and they didn't do it.
Yep, exactly. Nope, 100% agree. As you know, though, the TCPA is very complex. We always recommend, a third party outside legal counsel. You guys are at Insta Law, home of the TCPA Defense Force. You guys have been really good to us. We recommend you, but really any, telephone TCPA attorney is great. I wouldn't rely on the software provider as the be all end all. They just, they're more of a common kind of software platform. They're providing you the tools, to do stuff, but maybe the tool or the things you want to do won't fall within the law. So on your website, what's the website?
It's tcpadefenseforce.com. tcpadefenseforce.com.
You have a bunch of videos, guides, webinars. You almost have more stuff than we do on our website. The blog is really good too. Subscribe to the blog because they're usually the first people to talk about cases and things of that nature. But as I just said, don't rely on all these videos and everything to, hone in your entire strategy for TCPA compliance. Always go, talk to a TCPA attorney. So this was a TCPA case review for Rando, which is Nicole Rando, versus Edible Arrangements. It's 12:30 now. I'm getting hungry, really hungry. Joe Bowser from Insta Law, home of the TCPA Defense Force. And we'll talk to everyone soon.
Thanks, everybody. Thanks, Derek.
Thanks, bye. Later.